distribute this.
I don't know. I don't
Okay.
know, I don't know the village districts, so you're gonna have to tell me which village district that applies to, because I don't know.
Okay. It's 7:20. We almost have a full board before us. If anyone is recording, would they make it known?
I am, Mr. Chairman.
Thank you. This meeting is video and audio recorded. We will get started with our preliminary business in anticipation of our 5th member arriving. Copies of the agenda are on the front table if anyone needs them. The first is approve and sign an invoice for WB Mason. I already took care of that. Next is a discussion, Sandy Pines subdivision extension request. Do you have that in your packet?
We have a letter from
Yeah.
the applicant's attorney.
Correct.
This is a file.
So those files you just bought. If you follow the correspondence, you'll see where John notified them through the Permit Extension Act that they were good through February 18th, 2015. They are requesting an additional year to February 18th, 2016. Anybody need any more information?
I would just say we need to confirm the date of expiration to make sure it's accurate, and that's good for me.
Did you get to follow up on that at all, Dave? Is that, those dates accurate other than?
I didn't really look at that specifically. John's letter, I thought addressed it, and I'm sure he must have done the research at the time of writing that letter to provide that date.
What's the status? Have they built anything yet or no?
No. Questions? You need any further confirmation on that? Or? John's letter claims it was.
Yep.
John's letter claims it revised site plans February 18th, 2009. Okay. The initial approval was 2007. But something was done further in 2009. Plans were revised in 2009, which would make the time frame accurate. So what's the board's pleasure? A motion?
Make a motion, Mr. Chairman, to accept the letter on behalf of the applicant submitted to us by Vier and DG on a Flippo Ltd. to extend the project approvals for one more year from February 18th, 2015 to February 18th, 2016. For their written requests.
There's a motion, is there a second?
Yes.
Thank you. Any discussion? You good?
Absolutely.
All in favor?
Aye.
Opposed? Abstained? So moved. Do we have the legal ad for the? For the TDM? Oh, no, the green tabs for that. Can be a lot, it's all the same, What's this? Is it in there? Should have done this while we were waiting. Looks like it's all the same, with the green tabs.
Mm-hmm.
Not a lot of variety there.
Yeah.
They all got copies.
I'm gonna start with the green cards.
Hmm.
Fields and Thomas.
Those are for the IDA, I guess these are.
Oh, thank you. Narragansett Council of Boy Scouts.
Josh, this isn't a complete list.
Let me read these off to you.
We have two, this one for, and one
Is there another list
one for Plymouth.
Mm-hmm.
beyond that?
Ready with these two? Ready? Town of Plymouth Planning Board.
Yep.
Town of Bourne Planning Board.
Yep.
Narragansett Council of Boy Scouts. East Providence, Rhode Island. Commonwealth of Mass. Department of Environmental Management. AD Makepeace.
Suffolk.
Wareham Fire District.
Yep.
Town of Middleborough Planning Board.
Yep.
Town of Marion Planning Board.
Yep.
Town of Rochester Planning Board.
Yep.
Town of Carver Planning Board. These were all sent on the 11th of the month.
Let me take that back. Commonwealth of Massachusetts, I do have,
Okay.
on the top. Narragansett Council, BSA.
Yes.
Yeah.
All right. These were all sent on the 11th of the month. I'm gonna sign these cards. So, again, Beals and Thomas, Commonwealth of Mass, Department of Environmental Management. Council, Wareham Fire. That's all I have.
Yeah, that covers everybody.
Everybody?
Yeah, Field and Thomas, AD Makepeace,
Yep.
Fire District, towns of Bourne, Plymouth, Rochester, Carver,
Okay.
Now Standish, Commonwealth of Mass, Register, BSA, Narragansett Council.
Okay. These are the ones that, they just gave us, those from the 11th of the month. And these were sent soon, these were sent on the 5th.
Everything's good?
Yep.
And with that, we will open the public hearing for TDR, Transfer Development Rights Special Permit, AD Makepeace Company, northern end of Maple Springs Road. In accordance with the provisions of Chapter 48, Section 11, Mass General Law, and the Wareham zoning bylaws, Section 570, the Wareham Planning Board will hold a public hearing on Monday, November 24th at 7 p.m. in room 320, Wareham Multi-Service Center, 48 Marion Road, to consider the application of AD Makepeace Company, 158 Tyhonet Road, Wareham, Mass, care of Beals and Thomas, 32 Court Street, Plymouth, Mass, for the approval of special permit for the transfer of development rights on land at the northern end of Maple Springs Road, also known as Assessors Map 116, Parcel H1 in Wareham, Mass, within the R130 zoning district. Copy of the plans and application on file, Wareham Planning Department, 54 Marion Road, may be inspected during regular business hours. Any person interested or wishing to be heard in the proposed plan should appear at the time and place designated. And with that, I will.
Good evening, Mr. Chairman, members of the board, Mr. Pichette, Mr. Slavin, good evening. We're pleased to be here this evening filing under the town's newly adopted Transfer of Development Rights bylaw. With me this evening is Attorney Richard Serkey and Stacy Menahan from the engineering firm of Beals and Thomas. You've all been involved, whether in the planning board or on some other department over the past several years, as we've been before the board, whether it was many years ago for the Business Development Overlay District or a variety of planning efforts for some of the company's properties in Wareham. And it's been clear to the company over the past several years that a variety of the land should be put into certain types of use, such as commercial, such as we've done 100 Rosebrook Way and Rosebrook Place. Another parcel of a piece of property put into a commercial project on Route 28 with the Cape Cod Chopper Shop. And then there have been other properties over the years placed in a residential use, such as Tyhonet Pond South and Crane Landing. But there's also some of the company's land that the company believes should be forever placed in a green status. In Plymouth, we have put several, I think over 100 acres at this point, formally into a conservation restriction as part of a transfer of development rights bylaw in the town of Plymouth. We've sold different properties to the Commonwealth that are now under their stewardship, the Department of Fish and Game, and they'll be forever green. So we were intrigued with the recently passed transfer of development rights bylaw in Wareham to see how we would, if we could, put it to use, and we think we've got a very good example at the northern chunk of Maple Springs. Now, if you look at Maple Springs and its north to south characteristic, though we've considered a variety of projects over the years, we think long-term for the town and for Makepeace, it makes more sense for a piece such as that, abutting the state forest, has a whole host of interesting characteristics regarding endangered species, etc., that go into a conservation path into the future and remain green. And that what we're hoping to do is to harvest some number of the transfer of development rights bylaw. In reviewing the package, I'm sure you've noticed we went for a very discrete chunk of that land, not that whole parcel, for a variety of reasons I'll get to in a moment. But where we're cutting our teeth on this, we wanted the process before the Conservation Commission to be about as straightforward and limiting as we could be. As you know, your bylaw is a step above the state standard. So there was a considerable amount of more work than one might do in a community that didn't have such an enhanced series of bylaws. But Beals and Thomas worked with Mr. Bichette's office, and the Concom voted last Wednesday, I believe it was, to issue the finding that we needed as part of this process for the special permit. And we're out of the wetlands. In fact, it's real NULA. It's all upland. But because of our desire to get the first time, quite frankly, try to make a very manageable scale, we took the smaller chunk rather than doing the entire piece that we envisioned going into conservation status in the coming months, providing we're successful with this effort. We think it's a straightforward answer to the bylaw. We think the bylaw is very clear, and we think our answers to that are very clear. So I'll turn it over to Richard now to walk through elements of the filing, and then ultimately Stacy as we walk through the particulars of your findings. I will touch on one final note. Given the wastewater challenges that we face in this area, Wareham faces, one of our objectives would be to take these development rights from this upper area of rather remote land and put it into a village setting. Now, as you know, in our filing, we don't have an exact village at this point, but we're hoping that you folks will see this as a bookend process, and if we can get a special permit to withdraw the TDRs, obviously they would then go on the shelf for a period of time. We have to come back to you to secure a special permit for their ultimate landing spot. We think it makes sense at this point for a Parker Mill Ponds or Tyhonet Village to put these development rights into that setting and recreate a village setting such that you have a higher number of doors in a more densely populated area funding the wastewater solution, as opposed to what some might describe as the more traditional path forward in those types of developments. So having said that, Mr. Chairman, if you don't have any questions, I'll turn it over to Richard.
Thank you very much, members of the board, and Mr. Pichette and Mr. Slavin. Richard Cirque for the record. Since this is the first use of the recently adopted TDR bylaw, it might make sense for me to just give an outline of how I see it working, because it's important, if this is the first use of the bylaw, that we set a precedent that's accurate and complete with respect to the intent of this document. There are two steps involved in transfer of development rights. Each step involves a separate special permit application. Step one is a special permit application for the sending area, the area from which the rights are to be severed. Step two is a separate special permit application for the receiving area, where those rights would land. We're before you tonight just with respect to step one. We're seeking your concurrence that this land qualifies as a sending area, and we're confident that it does. And then we're seeking your concurrence that we have correctly calculated the number of sending rights that are there. That's all that we're seeking to do tonight. We're seeking your agreement as to whether this is a bona fide sending area and whether we've counted correctly. If we receive the special permit we're looking for, then at some point when a receiving area has been identified, then we'll be back before you for a special permit to land those development rights that have been harvested tonight into the receiving area. And at that point, there'll be a whole separate set of considerations that you'll have to ponder over as to whether or not the rights that have been harvested here today ought to land there. But that's for another day. Tonight, as part of what I've referred to as harvesting the development rights from the sending area that's before you, you have to make a threshold determination, and that's really the guts of what's before you tonight. You have to determine whether or not this property is significant enough to be preserved rather than to be developed. And if you make that determination, then you've basically determined that this is a proper sending area. In other words, do you want this land to be preserved forever? Because if you grant the special permit, the first condition, and I have a proposed decision for your review, the first condition is that the land either be subject to a conservation restriction in perpetuity, preventing its being built upon, or that the land be conveyed to the Commonwealth or one of its agencies or to another eligible grantee to assure the same thing. The bylaw says that the transfer of development rights, in order for an area to be qualified as a sending area, has to come from a piece of land that preserves or provides one or more of the following in the sending area: open spaces, natural areas, wildlife, flora, and habitats for endangered species, protection of groundwater, surface water, drinking water, as well as other natural resources, visual attributes, historical features, ecological significance, and value for recreation and/or town future water supply. Those are the criteria that you need to measure this proposal against, and to see whether preservation of this land preserves one or more of those values. If you do, then the rest of the process is very straightforward, because the bylaw says at that point, if the land contains no wetlands or areas that are buffers to wetlands, as we've determined last week by the negative determination of the Conservation Commission, then you take the area of the land involved and you divide it by the square footage in the underlying zoning, and you come up with a quotient that's the number of development rights in the sending area. It's like, if you wanted to use a metaphor, step 2 is like taking an ultrasound to a woman who's pregnant and trying to determine whether she's going to have twins or triplets or whether she's gonna be an optimum or more. It's determining how many transfer rights are in the sending area. That's the two-step process. But the first step involved is to determine whether or not this is qualified as a sending area. And your zoning bylaw places a premium on preserving and protecting open space. And it does not seek to make it hard for a landowner to preserve and protect open space if that's what he wants to do. All he has to do is prove to you that this is land worth saving, and then he has to make a simple calculation. The NULA divided by the square footage in the underlying zoning. And the quotient is the number of development rights. And that's it. So, if that's as clear as I can make it, with your permission, I'd like to turn it over to Ms. Minahan, who will go through the attributes of this proposed sending area to seek your concurrence that it's a piece of land that should not be built upon ever.
Is there any questions at this time before we go on?
Do we have the report from Conservation?
Yes.
I have a copy of the determination right here if you want to look at it.
Sure. So the sending area that we've established is broken into two pieces, and it's about 149 acres in total. The way we did it, as Jim mentioned, was to try and be as straightforward as possible. So although the TDR bylaw allows, I think, you to have some buffer areas included, we kept the entirety of the buffer zone and all wetlands outside of our actual sending area. So everything that's outlined as a sending area is NULA. So it's a 1-to-1 ratio. We did receive the negative determination confirming that, and we did stay actually 150 feet away from the nearest wetlands just to try and keep it as straightforward as possible. In terms of the attributes of the parcels, it won't take me too long to go through them, but it does have several significant items that meet the TDR bylaw criteria that Rich went through. It is proximate to Miles Standish State Forest, so in terms of contiguous open space, that's very important. It's mapped as priority habitat by natural heritage, and one of the items was protecting state-listed species, so it would do that. It's also entirely mapped as biomap core habitat by natural heritage, which is not a regulatory mapping, but it's an indication of areas that are worthy of preservation in order to help natural communities and rare species thrive. It's within a high-yield sole source aquifer. So it hits on, I think, all of the attributes in some regard, except for perhaps historical features that are in the TDR bylaw. It certainly meets that. And we also had included an evaluation of how the sending area complies with the master plan and open space and recreation plan per the bylaw. And as you can imagine, it's very consistent in terms of the preservation components of those documents. And in fact, the open space and recreation plan specifically notes portions of these the sending area as being a targeted area for preservation.
As I indicated, in the proposed decision I have before you, the first condition reads that the two sending area parcels will be permanently conserved through either a conservation restriction or through a conveyance to an appropriate land conservancy, land trust, or land management department or agency of the Commonwealth as part of a larger conveyance of land. And secondly, that the applicant shall file an additional request for a special permit with the planning board at the time the development rights are proposed to actually be transferred to a receiving area. And the future application will document that the TDR receiving area requirements are met at that time. Now, it's important to keep in mind that when towns establish their transfer development rights bylaws, these bylaws can be differently worded depending on what the town's priorities are. Sometimes the transfer of development rights bylaw requires extensive submission materials in terms of establishing the number of development rights transferred through a much more complex mechanism than what is present here in Wareham, through preliminary subdivision plans and appraisals and so forth. Wareham's bylaw does not have any of that because, and this is the rationale that I see for it, it values the preservation of open space so much, and conversely, because the development of this open space would strain the town's resources so badly that it wants to make it easier by encouraging landowners to go through this process, to determine the number of development rights in a piece of land that is worth preserving, and then to reserve for another day at a much more elaborate public hearing where the abutters that'll be notified will be the abutters who will have to be heard from on where those development rights land. That part of the process is for the future, and that'll be a much more involved public hearing because that will involve development in a receiving area at a density greater than what the underlying zoning would otherwise permit. Then you'll have to make your determinations at that time whether or not some or all of the development rights should land where we'd like them to land. But that's for another day. Today is merely for purposes of asking yourself whether this is an area where building should not occur, and I hope you agree that it is a place where building should not occur. And secondly, whether we've done our math correctly. And if you make those two determinations, then I submit to you that your work is done for tonight. And the fact that the room is fairly empty is not surprising because at the first part of any transfer of development rights process, the abutters are being asked to concur that the land in question should not be built upon. So who would be against that? But at the second hearing, it'll be a different story. So with that, I'd like to just submit for your consideration the proposed decision, which contains the three conditions that I've just read to you.
This is just one copy.
Yeah.
Well,
But I see this as a straightforward matter that frankly can be handled without the need of a continuance, if you don't mind me suggesting that.
well, the one question that does rise to the surface is the reference to underlying zoning and setbacks and frontages. And there is no frontage on this parcel unless it was in the freeze plan.
No, first of all, the bylaw doesn't we can get into more discussion about Maple Springs Road and the fact that there is access to this land and that access route can be improved to subdivision standards. But the fact of the matter is that the bylaw does not require that. It requires a determination of compliance with zoning requirements in the second part of the process, when the development rights land. All we're seeking to do is to determine whether or not the land ought to be preserved, and if so, how many development rights are in it. But the bylaw does not contain, the way other town bylaws sometimes do, a requirement that we lay out the proposed subdivision if we wanted to develop it in order to do the counting. The bylaw merely requires that if it's an appropriate sending area, we take the NULA and we divide it, in this case, by 130,000 square feet, which is the underlying zoning's minimum lot area, and we've done the count. There's simply no requirement. If that were the case, there would be language in the bylaw that requires, as I say, the submission of a preliminary subdivision plan and/or an appraisal and so forth and so on. That's not here. And it's because the town meeting, when it approved the bylaw, wanted to encourage the preservation of open space, knowing that houses rarely pay for the cost of educating the children that live there, knowing that the wastewater generator from residential housing puts a strain on the town's municipal resources, et cetera, et cetera, et cetera. So I don't think you need to go there because it's not there.
Well, there appears to be a conflict in the definitions.
Which definitions are you having difficulty with?
Between NULA and underlying zoning. The underlying zoning makes reference to setbacks and frontages. Now, you could.
Where's that? Which section of the bylaw are you looking at, Mr. Chairman?
Definitions, 570.3. I think it's the last paragraph. No,
Okay.
I'm not, I agree with everything you said. I'm just
Yeah.
trying to
Sure.
rationalize
The underlying
the whole
zoning,
picture.
that refers to the receiving area, because when you land these rights, you have to determine what the underlying zoning is to which the development rights would be added, if the board, by a special permit, sees fit. But in order to determine the development rights, you go to section 570.5. And the determination of development rights in sending areas requires you to establish the net usable land area, what we're calling the NULA. And there's no doubt about the fact that all of this land is pure NULA. It doesn't contain any land that is to be subtracted before you reach the NULA. And then you determine and calculate the development rights in a sending area by looking at section 570.5.2, and you take the number of acres, multiply it times 43,560 square feet, which is the number of square feet in an acre, and then you divide it by the minimum lot size, in this case in the R130 district, which is 130,000 square feet. And that quotient is the number of development rights, and there's an example set forth in 570.5.2. In that case, it's drawn from the R60 district, so the denominator in the quotient is 60,000. In our case, it's more than double, it's 130,000, because we're in the R130 district. But there's no requirement in this bylaw that requires us to establish the buildability of land we don't want to build on in order to determine the number of development rights we have. It's just not there. And as I've said a number of times, the fact that it's not there, I think, is a reflection of the town's desire to encourage the use of this bylaw by not saddling applicants with onerous requirements, such as, establishing that the land is buildable only, like using an Etch-a-Sketch to lift the cellophane and then say we're not going to build on it. No, the calculation is much simpler, and for good reason. There's little doubt in my mind, Mr. Barrett, as I read this, that that's what the town intended and what it wrote.
There appears to be conflicts in the document itself, that yes, if you take just the definition of NULA in and of itself, you come to that conclusion. But if you go to the basic, okay, how many development rights are there? If the property has no access, it has no development rights.
No. I'm sorry, I don't agree with that. Even though this property does have access. But where is that in the bylaw?
Well, under the underlying zoning.
What section are you
definitions
at, if you could?
that I quoted,
What section, George?
570.3, the definitions. requirements imposed by the Wareham zoning bylaws upon both sending and receiving parcels prior to any transfer of development rights therefrom or thereto, including but not limited to the following: use, density, bulk, height, area, setback, and frontage.
Well, how would,
Well,
Then-
what I'm saying
Yeah.
to you is, how do we rationalize a decision to move forward on this? How do we have a finding that says that this particular parcel has X amount of development rights without any demonstration that there is frontage available or could be created?
We do, I apologize, the scale is zoomed out, so it may be a little bit difficult to see. We did create an exhibit, so this is a much zoomed out scale, but it's the same orientation with the sending areas in red at the north. This is Plymouth Road to the south, which is a public roadway, and then we did highlight the existing agricultural access roads that could be fairly readily improved were these areas to be developed in reality. Extending from Plymouth Road, there are a few options as you come through, and we have driven those in a Chrysler, so they are roads as they exist now.
I gotta find that in here.
I didn't put it in there, I actually just found that out the other day, but our surveyor has driven them. So access could be attainable.
So where Plymouth Road ends, if you could just point to that, right down in there. So there's houses right down in there, and at that end. And then as you proceed up through, what,
I'm sorry to interrupt, I don't think there are houses right at this end where it ends. This is, Wareham Fire District
oh,
up in,
Yeah.
but,
okay, but it's a paved road or a public road to that point. From that point where your finger is there, now start to head up, what is all right there? Is that all vacant land right there?
yes,
Yes.
so this is vacant land,
So that,
forested areas and cranberry
like right in
bogs.
here, is this all yours? Is this all Makepeace
Yes.
property? Okay, is that buildable property?
Portions of it are, depending on where you are. There are some cranberry bogs, which I know are
Okay.
difficult to see from a
Sure,
distance.
sure, yeah. And then just let's go up a little bit further, so like right up in here, what is that? Is that buildable land that belongs to Makepeace just before your sending area?
This is forested. We have not done a NULA evaluation in this area.
Could you point so I could see it? There you go.
So in here,
That's all company land.
Okay, but so I guess, so then my question is this, so where the road ends down here, there's access somehow to get up to these sending areas, which, if you chose to, Makepeace could develop that road and build on this 149 acres or however much it adds up to.
absolutely.
So I guess, Mr. Chairman, can I ask a couple of questions while
Certainly.
I'm rambling here? I guess then my question, Counselor, would be, in the sending areas, it's 130,000 for, how many houses could you put there? Never mind the wastewater and all that stuff. I mean, if you were to develop that, how many homes could you put up there?
I don't know. But the bylaw doesn't require me to know because it calculates the development rights
Of square footage?
on the basis of square footage.
Okay.
It could have been phrased otherwise, but that's the way it's worded.
Well, I understand.
Yeah.
So my next question, Counsel, would probably be a simple one from my simple mind, is you're trying to withdraw 50 units out of there, according
Right.
to your document.
Correct.
And I'm gonna be honest with you, here's where I get lost.
Okay.
When I look in your section here, which is under your 2.26 in your booklet that you gave out here, I guess it's under section 3, 2.26, compliance with decision criteria. And as you head down to the bottom of that page, which says 2.4, by the way, I just look at the statement that it says the proposed uses within the receiving areas will comply with the requirements of the specific zoning districts used as a receiving area as allowed under the bylaw. And then I look at the bylaw that I have a copy here, and if I go to 570.5.3.2.3, it shows the minimum lot area of 5,000 feet. And the concern I have, and I've had it when I was on zoning, and I had it when I was a selectman, and I have it tonight, is if we're taking, you mentioned a few areas in your booklet, and I think Charge Pond Road, Tyhonet Road, and then what was the other one?
Parker Mills.
Parker Mill.
Mills, yes. I believe, off the top of my head, they're all, what, R30? So, in my mind, if you went into those receiving areas, and I read a statement in this 2.2 in your book, that you go with the underlying area, which would be 30,000 feet, you wouldn't, what you're looking to do is take a 30,000-foot lot in one of those three areas and use 5,000 feet as the house lot. Is that what you're telling me?
To be honest with you, John, we haven't looked at the receiving.
Okay.
We've looked at the sending area using this parcel.
Okay, I'm
We have
following
not, we have not spent time thinking about the next stage, because quite frankly, if we're not successful with the first stage, why waste any real time on the second stage?
Sure, all right. Well, quite frankly, I don't have a problem with your theory and what you're doing. The one problem I have is reading the statement in the booklet that you submitted with following the underlying zoning of the receiving area.
But that's for the receiving area.
It's the next step.
Yeah,
but
okay, all right,
bear
very
with
good.
me, I'm just looking down the
That's
road
fine.
here. And then I read through this thing here, and it says minimum lot area of 5,000 feet. That's what bothers me, is we're gonna take some land up there, 149 acres, whatever. We're gonna take the square footage and we're gonna withdraw a unit, an amount of units that we can transfer.
Right.
And it just seems to me, this is how I'm reviewing it, Counselor, so bear
Yeah,
with
yeah.
me, is we're gonna wind up taking those 50 units, and you may say, I wanna put them in 2 or 3 receiving areas
Right.
instead of 1. But there's always the chance, in my mind, you go into an area that's a 30,000-foot area, you know, down the road,
Right.
phase 2, step 2, and you come in and you say, we wanna put, 5, 6, 7, 8 houses on that acre or something. That disturbs me personally, because people live in a particular area and they have a 30,000-foot lot. And then we come in here with a development, let's say, a cluster development or a village setting, and we start to cram some of these 50 units in. That's the, are you following my question?
No, I do.
Absolutely.
I get you, although it's, if you will, part 2 of the story. But that's also part of why we've mentioned 2 or 3 locations that are islands unto themselves at this point. Tyhonet Village, it's us. Parker Mill Pond across from the Gleason Y, there's nothing there today. So it would be part, John, of creating, a new village or building off of a pre-existing village. It wouldn't be as if we dropped in between Crane Landing and Tyhonet Pond South. It wouldn't be one of those situations.
That's what I was heading at.
And I tend to think that's why you guys in town meeting approved a bylaw that ensured a check at both ends. A check when you withdraw and then a check when you land, so that it's all part of that thinking.
Okay, that answers,
If I can just add something to it, if you look at section 570.5.3.1, receiving area density, it states that the maximum number of development rights approved for transfer to the receiving area parcels shall be reduced if necessary to comply with the limits set forth below and any conditions imposed by the planning board in the planning board's grant of a special permit. So it's not as though when we get to step 2 and we want to land these things, that you're without discretion. You have discretion to decide that the number we want to land on a particular receiving area is too many.
okay, I would, believe me, you know me over the years,
Sure.
Counselor, I'd say no. But needless to say, I can buy that as long as we have the discretion, because when I read numbers that are put into bylaws of 5,000 feet, it just, I've seen some 40Bs over the
Yeah.
years come in here and they put 8 houses on an acre, and it's a home for somebody, but quite frankly, it looks like heck later. You say, who approved that? So a couple more questions,
Sure.
Mr. Chairman, if I can, while
Yeah.
I'm here. So the sending areas, we don't necessarily take a look at what you would develop there for how many houses you could put.
That's
or
right.
develop, we just take the square footage out of it. But at this particular time, is that piece of land is taxed as a buildable chunk of land, is it?
Well, what'll,
That's chapter status land today.
Oh, all right. So, then let me ask this, so when a piece of land like that winds up in a conservation restriction or,
Yeah.
or, transfer it to a state agency to
Right.
keep it, is there tax dollars still for the town or no? It's all gone at that point?
No, it's all, in that case, it would be gone.
It's gone.
Yeah, because it would just slide over, if you will, in its chapter status, into, say it went to the Commonwealth, it would go to a Commonwealth status or to a land trust or what have you.
All right, so once it hits the Commonwealth or a land trust, Jim, it's not,
You know, I don't think land trusts pay any tax
no,
whatsoever,
no,
but I'm not
well,
positive.
skip that, but it's not buildable anymore at that.
Oh, no,
point.
no, 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 no.
So that takes care of that.
keep in mind,
The conservation restriction would reduce the value also.
Right,
Right.
but so what happens though is when the tax dollars go away and it becomes a restricted piece of land, I'm concerned later that some politician, selectman or someone, comes up with, let's build there anyway. You know, that's all I'm after, you know. it's
Yeah,
like
conservation
beach- it's like
restriction
beachfront
would
property,
prevent
you know, they
Can't do
put
it, John.
You know,
you'd require an act of the legislature.
you'd find a way.
I wrote most of this law, John. Can't do it. I've gone through every piece of it.
That's why I looked at you when I said that, Alan, I was teasing you.
Okay, just as a comment to everybody, what they're asking for is the sending parcel, and we're getting into the receiving parcel.
I was asking a question, I
No, but I'm
understood
just
what
saying,
they asked
what
for.
we're discussing is the issues with the receiving, and there's a bunch of checks and balances, especially 570.8, which is the basically decision criteria. You have a lot of latitude on the board here for the special permit. What I'm hearing is that we're getting into the other half of the discussion, which really isn't what they're presenting right now.
That's okay.
You can't presume what's gonna happen until it actually happens.
All right.
So, I mean, what they're asking for is a decision based on the sending only, and that's it right now.
Yeah, and I've only spent like 4 minutes asking a few questions.
No, I'm not, I'm just saying in general, everything has really gone back to the second
Can I
half.
ask a question? on
Absolutely.
that?
George.
Just if I could, please,
Yeah,
because not that I'm worried about where you're sending it to, but,
yeah.
and I don't know that the TDR bylaw, to be honest with you, through and through. So my question pertains to, if we approve your request tonight,
Yeah.
in the TDR, are there any types of guidelines or restrictions relative to timeline for the transfer?
I believe if you, when we put this together, it was part of the special permit that the planning board would set itself. They could set the timeline.
Okay. And it sounds like you could use it on multiple properties, and not being an expert of the villages of Wareham, sadly, it seems to me that under section 570.1, it pertains to encourage and revitalize certain village areas. I'm not hearing that all of your properties that could be the recipient of the TDR are currently village areas, is that correct?
We wouldn't have to land the TDRs on our own property.
Right.
We can sell them to somebody else who would land them on their own property, subject to the special permit.
Yep.
And frankly, if we cannot land them, then we will have preserved this land without, through a conservation restriction or a conveyance to the Commonwealth or one of its agencies. And if we can't land them beneficially, then that'll be our problem.
Okay. So, and my other question is, if your request is approved,
Yeah.
at what time does the conservation restriction engage? Is it immediate?
The
Because to me, if we approve
Yeah.
it,
Yeah.
I would want to see that immediately.
Yeah.
Can I answer this?
Yes, please.
Efforts are underway to have this taken care of and secure a conservation outcome within a few months. Now,
what-
if we,
What would be the delay?
simply lining things up, that's all. Putting something in conservation, reviewing CRs, it's not as quick or as easy as one might think.
Okay.
Also, it's tough to get another party geared up, ready, when we're not sure what you guys are gonna do. It's the first time through here.
Right.
And the first time through anyway, you wanna give yourself some wiggle room.
Thank you.
But the reality is, if we're sitting here before you, telling you, we seek to not develop it, and then you give us the rights, I can't imagine we would then come running back in with an A&R to try to do something, or
No,
that you would look favorably
I know,
upon
I'm
it.
just, you know, I'm just under the impression that when you make a deal, you make a deal and both
Yeah.
parties do what they're supposed to do immediately. You know,
Yeah, to the extent you can immediately do
Right.
it. For example, again, I'm not trying to get back to part two, Alan, but it'll take some time to get any project of any complexity permitted, not on the local level, but on the state level. Because if you're going to recreate a village, you're probably into a groundwater discharge permit, which is a year, a
Right.
DEP. So when you look at how long we might ask these to be on the shelf, it's easily 36 months by the time you're through all of your permitting
Yes.
and all of your appeal periods.
that's why it was important to me
Yeah.
to see that the conservation,
We would make a commitment to you to lock down the conservation end of it as soon as humanly possible, and then run the risk of the TDRs
Yeah,
landing or not
that's what
landing.
that's kind of my question.
I can certainly represent that to you at this point on
Okay,
our
thank
first time through.
Thank you.
The proposed decision that I drafted mimicked the normal 2-year provision for special permits requiring them to be exercised within 2 years. And in this particular case, the only way that they can be exercised is by putting on a conservation restriction or making the conveyance.
Mhm.
If you want to make that a shorter period of time, that's up to you. But I reached for the 2 years because that's the traditional exercise period set forth in the general laws.
Mhm.
And
Just- No, go ahead.
the other thing is that this involves a gamble on the part of the landowner, because once he puts that conservation restriction on or conveys it to the Commonwealth, there's no looking back.
Right.
It's gone. And that's before he has the assurance that he can land one of them,
Mm.
or any of them, without knowing where the receiving areas will be. I mean, you, in a more typical situation, you might have concurrent special permits, hearings of phase 1 and phase 2. If we knew where they were going, and before a person neutered his own land by a conservation restriction or a conveyance to the Commonwealth, he'd want to know that he can land them.
Mm.
Not so on how we're doing it here tonight. What we're doing is we're willing to take that risk.
Mhm.
And I think there are no losers in that gamble, except potentially us.
You know, you bring up an interesting point, Richard, in that, in Plymouth, the CRs that we have placed on land that have been the source of transfer of development rights permits that are on a shelf somewhere. I think over 200 acres now are in CR without one landed.
Okay.
So that our practice, frankly, is to secure the harvest of the TDRs, put them on the shelf, line them up, know what you've got to go put into a project. And then keeping your word with, in that case, Plymouth, in this case, Wareham, moving as expeditiously as you can to put that area in conservation restriction, wrap it up and be done with it. Because we don't, you know, loose ends for us are just like loose ends for you. They
Well,
only come back to
One
bother
thing
you.
I've learned with the town of Wareham, record keeping isn't perfect.
Yeah.
So I like things buttoned up sooner than
Sure.
later,
Yeah.
so that I know that at least it's been done.
Did you say you had a draft conservation restriction?
No, I don't have that. I just have a draft decision.
Mhm.
Okay, the proposed condition number 1 of the decision would either be conservation restriction or conveyance to one of the eligible entities. So it's not clear which way we'll go, but either way satisfies the bylaw. Now, if you wanted to see the conservation restriction, if we opt to go that route, that's fine.
Might I ask a question
Sure.
about that? Because again, I
Yeah.
don't know the answer.
Yeah.
I know that the land you've chosen doesn't appear to be bogs or wet or streams or
No,
any
no, it
nature,
is.
so it seems like all per the requirements, but will there be any type of uses, is there any type of use allowed that you're aware of
Oh, sure.
after?
You mean recreational?
I mean, well, I know that, but I mean for any type of business purposes whatsoever, whether it's harvesting of trees or any of
No,
that
no,
nature.
the
Is there
most-
anything?
The most recent CRs we've done relative to land that is of a nature of natural heritage and endangered species
Yes.
would be, the only cutting would be that consistent with a habitat management plan.
Okay.
We're out of it. Say this moves forward.
Yeah.
We're out. That is no longer company land. We can walk it on a Sunday just like you could, if it went to a particular,
I think
went to any agency.
You know, sadly, my mind goes in a different direction that, you know, you put it into some type of conservatory and then you transfer that right to someone else who isn't quite as, nice as you folks.
Yeah.
And maybe they try to do things that they might, think are appropriate, and then the town has a problem.
Well, I will tell you, the two groups that we've worked with in my short tenure with the company has been the Wareham Fire District, and the Commonwealth of Mass. And in both cases, they have a stewardship mission. The fire district in their two parcels was to stop anything from happening on it. And they're by it every day. And in Fish and Game's example, they're all about the habitat. May they someday go in and cut the pucker brush to allow some species? They may very
I'm
well.
not so much worried about that, but I'm
Exactly.
thinking about somebody trying to do
Yeah.
something that might generate income or some change that maybe we don't anticipate today.
If we chose to go the conservation restriction route, keep in mind that has to be approved not only by the Board of Selectmen, but by the Commonwealth. So they have to be satisfied that the stewardship provisions
Yeah.
are more than just paper.
Thank you, makes me feel better.
Sure. And we'll seek, we will seek to place that in a certain conservation status as soon as we humanly could after the appeal period of this or any other decisions.
You touched on one point, public access. Is there a means to access this property?
Sure, go for a nice stroll, a jog, a walk.
How are you gonna get there?
Park at the end of Maple Springs and go for a walk,
Across your property?
right up the bog roads. Yep. Not vehicle,
No.
but walking.
I think I've done that.
Yeah, you're not alone, which is fine.
I have a simple question. We have this outlined in red and then a smaller sending. What's the red outline that we've got on the plan? What does that mean?
Are you looking at this exhibit or something there?
Yeah, this one, yeah,
The first one you,
same one.
So this is a slightly different exhibit, that Dave had requested that we submitted, just to show these sending areas within the parcel H1, which had been created by A&R. So that red outline is just a lot outline for that H1 parcel, which doesn't
See-
show up in its entirety on the plan that we submitted because of how large the H1 parcel is. So
Okay.
it's shown on this plan, but it just gets cut off in a couple of corners, so we submitted that version.
One of the reasons we did it that way was if you get off into all the corners to maximize potential TDRs, you say you came up here, well, then you're another 2 days walking the area with Mr. Bichette to prove everything. And frankly, the analysis by Beals and Thomas is extremely expensive. So we thought for the first time through, we would try to stay out of things, nice clean lines. David walked it in one visit, we were done, we weren't near it. So this is the overall A&R parcel you approved several months ago, but we thought this was the cleaner, easiest, simplest way of simply identifying two areas and asking that we extract from those.
Is there something that says that we can do this in a bifurcated fashion where we approve the sending areas without also where it's going?
Yes, the bylaw contemplates that as a possibility.
Where's that?
Okay, in section 570.6, land within the designated sending and/or receiving areas. Hold on.
The last sentence in that section says, if you're seeking a special permit, you have to own both the sending and receiving areas.
Or be,
Or have an option
PNS.
to purchase and sell, but we don't even know what the receiving areas are.
right.
How can you get a special permit?
Well, we've listed 3 locations within our current land holdings. And obviously, if we were to finalize a plan, we would come back here for the step 2 process of the part 2 of a separate special permit to actually land the TDRs.
I guess I still don't see how you bifurcate them, and I don't see, we don't have any evidence that you own, and you haven't committed to a parcel. I mean,
We
it
haven't
looks to me
committed.
like you're supposed to have a sending parcel and a receiving parcel, and you own the 2 of them.
No, Mr. Reed, I don't believe that that's required. And give me a second and I will point to the provisions. If you look at the section 570.8 decision criteria, it says in the second paragraph, special permits, plural, enabling this transfer of development rights and the combination of those rights with development rights pursuant to the underlying zoning may be granted by the planning board upon its determination, et cetera, et cetera. I mean, what's contemplated are 2 special permits. One, to preserve the sending area, and 2, to allow the rights that came from the sending area to land on the receiving area. And there's no requirement that the 2 be heard at the same time. Under section 570.9, governance, the filing and public hearing requirements shall govern special permit applications and decisions. I mean, if they all had to occur simultaneously, we'd have one decision following one hearing, where you would consider not only the merits of the sending area, but the merits of the receiving area. But in my experience, under transfer of development rights bylaws, it's rare that that occurs. Instead, you harvest them, and then you use the fruits of the harvest another day when you've found a place for them to land, assuming the planning board can agree that they ought to land where you want them to land.
See, Counselor, I had the same question, to be honest. You know, when you read through 570.6 and you get down the bottom, it says, applicant seeking a TDR special permit shall own in fee simple their respective properties affected by the TDR special permit in the proposed sending areas and the proposed receiving areas, or be in possession of a valid purchase and sale, yada, yada, yada. Then you get to the next page, the receiving area property owner may compensate the sending area owner with the mutually agreed upon value of each
Right.
development right transfer.
Right.
And that was the question I had of, if you sell them to someone other than the company yourself, if you sell them to some other builder or developer, that's where I was about to head before Alan said that's phase 2. That was the concern I had, is if you take those rights and you put them on a shelf and you say, nah, I don't wanna do it down on Charge Pond or the other Tyhoon or whatever.
Yeah.
And you sell them, and someone else comes in here and sits here and they're looking to jam houses in. That was my concern. But that's what I read, that's how I read it under procedural requirements.
But-
So
but that-
570.6, Jim.
Yeah, no, I'm
I
just trying to understand
what-
your point.
Yeah, well, it just happens to say, sending areas and proposed receiving areas, you know, you're supposed to have them both, or a purchase and sale for these.
But we do own the properties that we've mentioned.
You do, but also in your statement tonight, or your council's statement tonight, you may sell those rights to somebody else.
No, we could under the bylaw, we have no plans to.
Okay,
And even if we did, they would have to come to you folks for a special permit to land them.
If I go back to Rich's
Yeah.
570.8, I'm looking at the very first sentence. The special permit authorizing the transfer of development rights, so reference Wareham assessor map with lot numbers of both the sending parcels and receiving parcels.
Right, so the next, when we come back,
The permit, it's, to me, it says you're
Yeah.
gonna have a permit, and it has to, when we give a permit, it has to show both of those.
did you want to say?
I was just gonna ask if that was relating more to once you're actually transferring the rights.
Yeah, we're not transferring them. What we're
You're
seeking to
looking
do
for
is,
a permit.
we're looking for a permit that agrees that this piece of land is worthy of preservation, and this is the number of rights that we can harvest from it. We're not gonna transfer them yet, though, Robert. We're not gonna transfer them yet until we have a receiving area, okay? We're just seeking to put them on the shelf. The transfer will come when they land.
I understand what you're trying to do, I'm just
Yeah.
reading the thing, it says the special permit.
Yeah.
I mean, it looks like it contemplates only one permit. It's
Well, it talks
not a
about,
well-written bylaw, I
All right.
think we can
But-
agree, but
but look at the definition of transfer of development rights. That is defined earlier in the bylaw in section 570.3.
Say it again.
That, it says the voluntary exchange of development rights between one or more property owners. Upon receipt of a TDR special permit, designated development rights may be transferred from one or more sending areas to one or more receiving areas. We're not here tonight to transfer anything. We're seeking merely to count.
exactly. And I'm in total agreement
Yeah.
with what you're saying there.
Yeah.
But Counselor, as you read through this 15 or 20-page bylaw
Yeah.
that we have here, there's sentences written in different sections that say different, is
Yeah.
what we're saying.
I think any document, be it a bylaw or a contract or a statute, can always be improved upon. But I have little doubt, for whatever that's worth in your mind, but I have little doubt that you can count what's in this sending area without having to identify where that plane will land, or if it'll land.
Exactly.
We're just trying to see how many people are aboard, all right? And the second stage of this process that we talked about tonight, that's the heavy lifting. This is light.
The issue I have is, just reading section 570.6, applicant seeking a TDR special permit shall own, in fee simple, both parcels, or they'll have a signed purchase and sale. To me, that tells me that the townspeople, that was their intent, and for me to just nullify or feel that that's not important would be concerning, because we don't see what is written here. So,
Well,
I think that's troubling for me.
well, we're not gonna transfer,
I understand that, but
Yeah.
this doesn't address what you're saying clearly enough. To me, this kind of shows me that the town people of Wareham approved this TDR with this language in it. And for me to just arbitrarily throw that aside and maybe interpret it my way or your way or whatever, I'm not quite sure that that's the intent of what the townspeople wanted, so.
But may I ask a question?
I need clarification, I guess is
Yeah.
what I'm
Could I ask a
saying.
question?
Yeah.
If a bylaw is approved at town meeting that allows land to be preserved, and then a subsequent plan under a special permit to be approved by the same, the planning board.
Yes.
It would seem to me the only person who stands to lose anything in this game is the person who has the transfer of development rights bylaw, the transfer of development rights, or the property owner of the project. That the town is ensuring a chunk of land stays green, and then when this comes back to be landed somewhere, you could choose to not accept that proposal, make it much smaller to avoid your concern, Mr. Cronin, or what have you. So just from attending a bunch of different town meetings, it would seem to me that the ultimate objective here was to ensure land of a certain characteristic was preserved.
I don't disagree with that.
And this is a way to do that. And frankly, we're the ones at risk when we come before you in the future for some subsequent landing area.
I understand that. I'm just saying that I have concerns as a member of the board, reading what the townspeople approved and just maybe not paying attention to it for, as you said, I see the betterment, I see the improvement, but I'm
Which
not quite sure that I feel comfortable with it.
Which sentence,
Okay.
you're talking about the last sentence of 570.6, on the last sentence of the first paragraph, the one that says applicant seeking a TDR special permit, is that the one?
Yes, and then it continues to the next page a little bit, and I thought maybe it was clarifying it, but it didn't seem to clarify it for me, so
Applicants are not required to own both the sending area parcels and receiving area parcels for a TDR special permit. Distinct property owners may enter into a voluntary agreement transferring development rights from one owner to another.
which I think they addressed with that possession of a valid purchase and sale agreement.
Right.
So, again, I was looking for continuation and some clarification, but I didn't find it, and please, I apologize, but I'm
Yeah.
not an expert on this document, so.
We can, our intention, as you've heard, is to land them on our own property. At some point, at locations yet to be determined, through a separate public hearing. Under the bylaw, we would have the right to sell the rights to somebody if they wanted to, and then they would come here, not us, and seek to land them
I understand that.
after they bought our rights, and they may not be able to land them. So there are no guarantees, no
I
bets.
understand.
Let me put it this way, and I'll do it through a rhetorical question to my client to my right. If in fact, if you get the special permit that you're seeking tonight, and you put a conservation restriction on, or you convey it to the Commonwealth of one of your agencies, why are you doing that if in fact you don't know where they'll land, whether they'll land, whether it'll be on your land or somebody else's? Or to put it this way, why are you doing this?
Because we think, A, this piece of land should remain green, and B, that we can come up with a project that makes sense, and that you guys may not land all 50, but you'll land 48 of them. Because we're not gonna bring in a project that keeps you up at night, Mr. Cronin. We'll bring in a good quality project.
I sleep during the day.
But you, but we will seek that village-style density instead of sprawl.
I asked the question only because it seems natural to inquire why a person would do this.
No, Counsel, it's an excellent question, and I agree with that question. You just have to appreciate the fact that we're getting a copy of this bylaw, and there's 2 or 3 sections that say you should own both, or you should have an agreement on one. There's another that says you should show the book and the page and the parcel number and what have you. So it would be disturbing for someone sitting at home watching, saying, well, geez, I'm reading that 10 or 12-page document, and why did they give them a permit? Because they didn't show them what lot they're putting it on. Yet that's what it says in this document. So that's, I think, why some of the other members and myself had those questions. Personally, I think you're on the right track.
Yeah.
Right.
I haven't seen anything cheesy be built out of this company yet, so I wouldn't expect it to start with this first TDR, so.
Well, thank you. And I don't mean to say that this is as obvious as apple pie. It's not. But I have complete confidence that the way we're going about it is a process which, if it inures to anybody's detriment, it's gonna be to the company represented at this table,
Right.
not to the people of Wareham.
And as you pointed out earlier,
Yeah.
this is our first
Absolutely.
exposure to this, so.
It's important that it be done right.
If we scrutinize it a little
Right.
heavier than might have been anticipated, then.
I understand.
Could we present some questions to the town's legal counsel for guidance? Where this is the first
Certainly.
time?
Where he was key in developing this, he may be able to.
I mean, he might be able to guide us so that
Smooth out some of
we
the
can feel
bumps.
comfortable. Like I said, I'm just a little uncomfortable reading a document that was approved by the townspeople and circumventing some of the language and knowing it. I mean, certainly.
And I don't, I mean, that first sentence in 570.8 talks about the special permit and identifying both the sending and receiving parcels. Does, to me, I don't know how we give you a special permit. I'm not even sure we could give you a special permit, a sending permit. I mean, there's no such thing, I think, as sending permits.
I think
Maybe
that-
it should. I mean,
I
I can understand why you'd want to do it.
Yeah.
But it sounds like there's a permit, and it has two parts to it.
I think what you're hearing is that everybody wants to move this forward. and-
Yes, I understand.
And is comfortable in the theory.
Yeah.
But we're looking at,
Well, I'll take my lead, of course, from the board. If you would like me to formulate a series of questions to Richard Bowen, I can do that. On the other hand, since Mr. Slavin is here, I need to ask whether I can do that without seeking the selectmen's permission.
No.
Okay.
I'll send a note off to Rich now while I'm here. The board needs to vote that they want to seek counsel and request it. Since I'm here as the chair, I can go ahead and do it. But you have to vote for it first.
That seems logical.
That's all. Just make a motion.
well, I think along with that, you have to compile the questions that you want asked.
Do we have to have the questions ready tonight, or can we put together some email
Oh, no, I think you can
streams to?
digest this a little and
Hmm.
Yeah.
further.
You can submit, but I can just simply ask them, as the law is written, can you split this into two parts? Can you initially initiate a
Hmm.
permit for the sending piece only, and then go back and do the receiving? Because that's really the question right now.
I guess that's probably the biggest,
I don't think, when we put this law together, I don't think we ever contemplated doing it in sections. When this was put together, since George, you were there, and David was there, we were doing all this, we never discussed that. We only discussed it as a complete function.
Can I
So-
make a comment, Mr. Chairman? The other question I think that probably should be asked is, in terms of the sending parcel, should that be a parcel that has the ability to be developed? In other words, you don't want to take pieces of land that are potentially landlocked pieces of land and then assign development rights to those, okay? So that, to me, is probably the biggest question here, not just for this project, but for any application that comes before us as far as TDR goes.
I think it's already in your discretion, the way the bylaw is written, that you have the discretion of whether or not it's an acceptable piece of land in the first place. It's right in there, I believe, in the beginning.
Well, the reason I ask is because you don't want to take a piece of land that otherwise couldn't be developed anyway, and then all of a sudden give somebody TDRs to transfer somewhere else that they could use.
Right.
I think it's already there.
So,
to that end, I can see the concern, and I voiced it a little differently earlier. I think where this is one large property owner, I think you could, if need be, you could demonstrate where you had the access and the frontage. During the creation of, or the fine tuning of this bylaw, density bonuses disappeared, but not having to illustrate subdivision roadways and things of that nature kind of took its place. That space that would be allocated to roadways and are kind of a density bonus in itself. And the purpose of this bylaw, one of the selling points of this bylaw was to eliminate sprawl and miles of subdivision roadway and access roads. In this particular case, where the applicant owns everything between these parcels and a paved way, you know, it's a different circumstance that if somebody came up and had no control over the land between them and were truly landlocked. In my mind, anyway, I don't know how the
Yeah.
Well,
board feels.
exactly, Mr. Chairman, and that's why I'd asked, like, who owned the land in between, and how
Yeah.
could you get a road to it?
Right.
And how many houses could you build there? So I had that in the back of my mind, is this really a dead piece of land somewhere that they can't get to? And then the engineer showed us how it works, you know, how you could get there, so.
But the other question is, do you need to go through the special permit process to agree that there's 50 developable units there? That's the question, I think, is. Or do you say, okay, we agree to 50 now, and then you come in with the total package, sending, receiving one special permit, which.
Are you talking about like a preliminary opinion of the board, not?
Well, in the discussion that this whole process
Yeah.
is laid out as one special permit.
We didn't read it that way, as you can tell.
Yeah. Is that I guess we,
How do you deal with a market reality, George, of the timing is not always that neat, that you have a sending area at the same relative time that you have a receiving area? The market, for example, we could never land these today, we know that. There's not a sufficient residential market in Wareham today to land. We know that. But frankly, we'd like to start dealing with Maple Springs, putting it to bed. And we'll start with this nice northerly section because we think it fits the bylaw perfectly. And we put them on the shelf, and guess what? If we come back in 2 years from now and you guys don't like it, I guess we made a mistake. But, you know, to us, it's a rolling, we secure a number, put them on the shelf, and then we come in and ask to land them somewhere. You know, I don't know how you do it with one special permit that isn't dealt with until such time as a receiving area, or if there is a receiving area. Because we could all be working, you know, all diligently on our way, and then a groundwater discharge permit could get caught up and appealed for another year. And then, to me, again, I'm sitting here as a member of town meeting, sitting here saying, okay, what's at risk for me as a member of Wareham? That a piece of pucker brush stays pucker brush, and that TDRs never actually get landed. I understand your strict constructionist review of the language, but for Wareham, that's the only thing at risk. Land stays green, and I made a mistake. In my view of, my read of it.
I view of
How
what
many
we're doing here
mistakes have you
tonight.
made?
What's that?
How many mistakes have you ever made?
Oh, talk to my wife. I don't think you have enough time this evening.
What we're doing here tonight is what you might call a rainy day project. All right?
Sure, I get you.
now, in going over your proposed decision, you do reference a future application.
Right.
Yeah.
We don't pretend that we're dealing at all with receiving areas
And,
here.
and like you say, from a practical matter, it's not a one shot, one size fits all.
It's not that neat,
So,
especially where our land is covered by a large MIPA process. So the easiest part of what we do here will be coming back to the town seeking a special permit to land. You know, flying through MIPA for groundwater discharge, traffic, and all those other things will be, that's a timeline almost on its own.
Again, it's important to focus on the definition of transfer of development rights, which we're not at yet. We're creating them, we're not transferring them. And we're merely seeking to establish a sending area and counting. Transfer comes at the second stage, once we've identified where they would land. But what you might do is if you seek the advice of town council, you might want to send him the proposed decision as a framework to see whether that's a workable document or not. And I have it on Word, of course, so I can email it to him if in fact, you do seek his opinion. So that if there are infirmities in it, then he can edit it.
Questions about? This is actually, you're supposed to issue a special permit? Is that it?
It's a special permit to do nothing. All right? It's a special permit to basically, to harvest,
No, I
yeah.
understand that, I just don't.
It's counterintuitive in that sense, because it's not a special permit to build anything, to use the property for anything. It's a special permit to commit to doing nothing.
I understand what you're saying, I just can't get around the language in the bylaw.
Right.
So I guess, was I correct at the second question, and the one that you had raised also was, when it talks about development rights in that definition, the rights to develop are determined by application of, the zoning bylaw, the subdivision control, and the question is, does that mean you look at those and making some determination of whether this is does this have to be a developable area? Is that the question?
Well, it's one of them.
Yeah,
Yeah, I was trying to-
that was the question I was bringing up, is just in that, you just don't want to take a piece of land that doesn't necessarily have true access or frontage on a road and start handing out TDR rights to that, where if it couldn't be developed in its current state right now, that's the question, that you need to be careful of. Because again, not just for this project, but what if somebody down the road views what is done here and they want to come in and look at their 30 acres of land that they could never get access to? Now they want to get TDRs out of it and transfer them to somewhere else.
Well, sell them to somebody else.
Right, you don't want to do that.
We don't want to.
That's not what the TDR
I'm not thinking
was intended to do.
I think that if you had a landlocked piece of property,
No matter what,
which,
stays natural.
as its name implied, could not be accessed by anyone, you'd be hard pressed to find that it qualifies as a sending area.
Sorry.
Because if the only way to get there is by helicopter,
Right.
then chances are it's not gonna have the qualities that would make it a true sending area. But that's moot in this case, because
But-
to get there from the nearest public way, you can use you have to traverse the landowner's own property, and there's a way that provides access to it already. Not a subdivision road, to be sure, but there is access.
And just for what my 2 cents is worth, if the benefit to the town is that the land stays natural, I'm not convinced that I would need to see direct access to the land if the true benefit to the town is that it remains natural. So, in this particular case, it's easy to demonstrate access to that land. But if I had 50 acres of land that was landlocked, and I wanted to, granted, it doesn't have a lot of asset value because it's landlocked, but if the town truly believes that the asset value is it stays natural, there's a value to that, I think.
Right.
So,
Absolutely.
I'm questioning, in my mind, again, I hate
Yeah.
doing this to you, but I'm questioning the document as written a little bit on both sides. So I'm trying to figure out what is really the intent of the townspeople. What did they really want to see? And,
The open
So-
space, I think.
I don't know that there's access, I mean, it's a private road that don't necessarily have access if this was.
right,
Well, you get to this parcel by traveling over the remaining land of the landowner, which has frontage on a public way.
But if this is, say this is transferred to trustees for reservations or something, they wouldn't have,
No,
there's no
the-
legal access to it.
We'll give them access. With the transfer document would provide that, the deed would provide an appurtenant right-of-way.
Do we get to see, before we vote on this, do we get to see where it's gonna end up, or with who, or?
Yeah, we honestly
I don't even know yet,
we don't know that.
except it will comply with the bylaw.
I can assure you, though, that in the discussions that have taken place, one thing that is a prerequisite is that there be land access to this land.
That's not in the bylaw though, so.
But I can represent to you that will be part of the documentation, be it a transfer to the Commonwealth or one of its agencies or an otherwise eligible grantee, or be it a conservation restriction.
Under your reading of the bylaw, sir, who makes that decision?
The applicant does. He has the choice.
Okay.
He has the choice, because under the bylaw, both options are considered equivalent.
And you would get to pick the person?
Yes, but it can't be anybody. It has to be either.
No, I understand.
Yeah. It has to be either a public entity or
I think it has to be accepted by the planning.
that's acceptable to the town and to the Commonwealth.
It has to be accepted by the planning board. It's in the bylaw.
Okay.
I can go find it if you want.
Yeah, it was always my thought that the CR or whatever
It's under the control of the
method
It
planning
said-
board.
of preserving it would be,
If you look at 570.7, either a conservation restriction or a transfer of fee ownership of the sending parcel to one or a combination of more than one of the following: the town, a nonprofit organization, the purpose of which is the conservation or preservation of open space, or the Commonwealth of Massachusetts. And we have to, obviously record either the CR or the deed, and,
Any transfers that we've done in this type of situation have ensured public access.
Right.
Why would you keep ownership and the liability that goes with it with a conservation restriction?
We wouldn't. You transfer that to some other entity. The like an appropriate entity.
The ownership?
Yeah.
Yeah.
Different groups, sometimes you'll transfer the fee and then a CR on the fee. Sometimes you'll transfer the fee to an entity by which it's automatically under a statutory CR. But once you're not gonna use it, frankly, why own it and incur the liability?
That's right.
Yeah.
No reason to. Again, to your issue, the incentive to get rid of it
Right,
and put it in the CR.
yes, yeah, I understand.
may I suggest that, as a procedural matter, that if you're gonna seek the advice of town council, if it's acceptable to the board and to the selectmen, perhaps invite him to be here at your next meeting, so that if there, well, it's up to the town's coffers, but, so that if you have more than one question that isn't anticipated, he'd be there to answer, but I can't.
The zoning bylaws is John Whitten.
Oh, I'm sorry, okay.
But John is part of Mr. Bowen's
Fine.
firm for this.
But I mean, that,
Not that easy to get done.
okay,
we can make that request.
pardon me?
Yeah, you can make the request.
We can make that request.
Yeah.
So, in all honesty, who are we dealing with, Alan?
And zoning bylaws, you'd be dealing with John Whitten.
But he works with Rich Bowen?
He works under Rich Bowen
Oh.
for the town. So
Okay.
any of the building, zoning, conservation, et cetera, Mr. Whitten handles that part.
This is a public hearing, if anyone in the public wishes to comment on this proposal,
Speaking for the water department.
come forward, please, and identify yourself. Limp forward.
Look forward, there you go. Oh, thanks.
One of the volunteer jobs.
Mr. Chairman, I'm J.T. McGinney. I'm the chairman of the Board of Water Commissioners, as you're aware, and I'm just here in support of Makepeace keeping the as much land surrounding our well fields as open as possible. and that's all I have to say.
Where are the well fields in relation to these?
They would be south of that,
Could you show
I
us
believe.
on the map? Is it on the map or no? Is it within a,
Portions of at least portions of the sunning areas are within the zone 2 as well.
and is the water flow to the well areas?
North and
Yeah,
south,
long,
close down.
guys, the long term here would be if we can figure this out up north, we'll march our way south. It's not a national secret, right? Go to the most remote and figure it out and then work your way down. And then we'll see you for a landing spot somewhere, to my point, George, of how it's not always convenient. You don't have a sense of what numbers you're gonna get.
Yeah,
Let alone the market.
Honestly, the timing was not considered in the
Yeah, I understand.
conception of this bylaw. I mean, that was. Want me to help, you need help putting with the well side?
No, I can't, I didn't really,
This will just become a
yeah, okay.
Yeah, I think.
I know where your land is.
Right down here, isn't it, down this way?
Yeah, I was gonna
There's
say,
here, there's here, and it all flows this way.
yeah. I'm trying to recollect in my mind how many acres we have, and it's not coming, it's not computing.
I couldn't pull up a total either, to be honest.
No, it's not computing right now. But, if it stays green, I'm happy. Sorry.
Piece of paper.
The only other question is, there's a provision for the board to have a consultant. Should we have our engineer take a look at this and look at the calculations and the determination of the area and
I think he has done that informally and found it to be pretty straightforward as far as the new calculation, is that correct?
As far as the calculating of the potential TDRs, I think he agreed with how that was done. He did also question the issue of access to this parcel.
Can I just ask a question on that? What's the question of the access, though? If what we're saying is legally accurate, so how would one question the access?
Well, initially, when I first asked that earlier this evening, Jim, was you have a piece of land that's the northerly piece of your property, and your engineer described the road, the public road ended, and then it kind of winds up through your other property to it.
Yeah.
So as Mike asked, and as I think George or even David mentioned, is that a buildable piece of property, which I asked you, how many houses could you put there, and can you get to it? With the train of thought that, what if you can't get to it?
Sure, no, I understand that.
Why are we giving you
Sure.
50 units to
Yeah.
put somewhere else if it was landlocked? That was the intent of it. So if it was to fail, or we weren't in approval of it,
Yeah.
you as as the owner could develop it, you could make a road up there and put in your houses or whatever you wanted to do. So my initial intent of the access to the property was, the question that Dave brought up afterwards is it a worthwhile piece of property to consider?
No, I understand that. David, is it a mystery in your mind?
Well, the question came up that the lot as it sits, lot H1 right now, has no frontage on any road. Is that an accurate statement?
As it sits here today with the gate?
As it sits right now, the way it currently is laid out, does it have access on a road?
It has access, but not on what you would call a road or a street under the subdivision control law or under the zoning bylaw.
Right, so if you were to go to try to get a building permit right now for a house on that lot, could you get it?
Right now, with nothing further done, no.
That's the
Okay,
question.
so then we
That's why
just
I
go
asked.
through some more steps and then we can have the road? So
That's-
what's the difference though?
Well,
This,
No, I'm just trying to learn what the difference is.
just in terms of what the TDR is looking for, it's looking for, does the sending area and the receiving area conform to the underlying zoning? And in this case, it doesn't sound like it does, because you don't have frontage on a road for your sending lot.
But we would probably go to what we've already talked about and say, we think the bylaw is quite clear and doesn't call for that. But even if it did, so we spend 3 more months, it becomes the Engineers Full Employment Act, and then we spend a bunch of money on, that doesn't matter, because we're gonna hopefully not do anything. So where's the difference in the outcome in this case?
Well, in this case, there might not be a huge difference, but like I said, we're looking at projects as a
Unintended
whole.
consequences, okay.
And we can't just look at the TDR as it relates to just your project. We have to look at it how it relates to any project that might come before the planning board. And so that's,
sure.
that's what's important.
No, the unintended consequences, I
Right.
understand that. I was just trying to hone in on what your concerns seemed to be, and I wanted to understand it, because let's agree, your concern is real today, a few more months, we spend some money, and then the concern is, okay, fine, you're going away, but what have we really achieved? We've spent some money on Engineer Full Employment Act, and what has that really done?
Right, so again,
Okay.
I think the concern is to determine if a property has development rights initially as it sits. If it doesn't, then it doesn't. If it needs to have some other things put in place in order to make it buildable, then that, is the question. And again, not so much maybe as the board looks at it for this project, but we have to consider any
That's-
projects that we're gonna review.
Well, no doubt out of this evening comes a few potential edits to this come the spring.
This
I would
parcel-
suggest everybody look at 570.5.
Point.
570.5. Just read it.
570.5?
0.5.
Yep.
I think it answers the question.
Answers it, but restates it.
Yes. But if you look at what we're talking about for developable land, it just says, says land, by the zoning. So if you're in R130 with I think it's, what is it? We have one of them that's 130,000 square feet for a house. So you take that particular number, divide the number of square footage of total land, that's your developing units. It doesn't say anything else but that.
That's not your true development, right? Because you're still gonna calculate for road frontage and this and that has to be put on, the infrastructure's not in place.
But we didn't do it that way. We just did it by number of square
Just
footage.
TDR.
This is part of one of your freeze plans from years ago that,
Yeah, I believe so, George. Yeah.
so it is on a lot that had frontage on a,
Really has nothing to do with the freeze plans, though. It's a straightforward application of this bylaw. Simply put, we're not seeking to grandfather any undersized zoning requirements. The
no,
bylaw.
but at that particular, I'm not saying,
Yeah.
at that particular time, you demonstrated that the larger lot had the possibility of creating frontage on
Yeah,
a public way.
yeah. And that,
And this is a parcel that is part of that lot.
that's right, that's right. No, that's a good point, I see where you're going. Because all of the land was to be included within one or more freeze plans. And,
Alan, that section you just mentioned,
Yeah.
point 5, says, the area is based upon the existing by right underlying zoning, which we know, and the physical characteristics of the site. Now, when they say that,
It goes back to It goes back to the beginning when it gives you the reason for it. It talks about the land having certain features, et cetera. That's what it's talking about.
but does that mean the board could look at this and say, we don't think you could really build anything on that, so we're not gonna count it? Or when it says that, does it mean just the physical characteristics as identified later on?
I think it's actually listed in the beginning, the characteristics of the land.
So we could look and think, you really can't build this section here, we're not gonna count it?
I can't answer that. That's up to the board. It's a decision of 5 people.
but I can't imagine that there's anybody who could say that if this land were to be developed, that it couldn't be developed by means of a subdivision plan that would widen the Maple Springs Road as we see it now into an approvable subdivision control law road. I mean, it's not as though we need an easement from anybody else, or we need to buy land from anybody else, because it's our own land that's adjacent to the closest public way. So if we wanted to create a subdivision road that went to the doorstep of this parcel, there's no doubt that we could.
No, my question, I
Yeah.
guess my question, maybe it wasn't clear. When you look at the physical characteristics of the land, does that mean you could look at it not in a legal sense, but just in a development sense and think?
No, I think it's talking about the qualities that Stacy went through with you that make it important to preserve.
If it was a gravel pit
Right.
that had supplied the world with its gravel, you probably wouldn't want to TDR that.
Right.
Why would you give somebody, rights from a gravel pit? However, given that this is pristine pucker brush in southeastern
Well, I
Mass,
understand, but
it would be-
I guess that's my question, is does the board have any leeway under the bylaw to look at the physical characteristics of the site and decide that either they don't want it, or they don't think all of it should be considered, and we'd only consider a certain square footage of it?
Yeah, I think you have that discretion if you felt that the attributes that Stacy enumerated and that we've listed in our application don't apply to all of it.
Say half the area was a used gravel pit and half was pristine. I would argue that you folks would have the right to say to us, no, get out of here, we'll give you half, we're not giving you for the gravel pit. Gravel
So-
pit doesn't really contain the characteristics you're seeking to continue.
I
Well,
see
there
some
are two-
pretty tight gradients there, I don't know.
Yeah.
There's some great gravel out there, but it'll remain out there.
Now, and where is this place? I have this little road running through here, which also looks like it's the gas line easement, is that
Gas line
correct?
runs that way.
Runs this way, okay. And where's the road? How would I get to this?
Walk down there. We want- give them that meeting,
I
so-
don't think I have a more zoomed out view than this, but this is the public road
That's Plymouth
to
Road.
the south, Plymouth Road.
Okay,
And then the yellow, I mean, there are more than what we've highlighted in yellow, but the yellow are the major agricultural access roads.
You won't get there tonight because of a series of gates that belong to the company, the power company or the water
And we
district.
know that. I think everybody agrees with that. I don't think.
Tonight, you just can't go driving out there. Tell us you'd like to go for a
And
visit,
I've
we can
been
all.
lost
I
completely.
know, I would.
No, you know what, it's actually, once you're there and during the day, it's a straight shot north,
He's a lawyer.
straight.
He'll put you on the road.
But here's the.
He sees the diary.
If anybody would like to take a ride out, Mr. Chairman, obviously just give us a buzz, we'll open the gates and off you can go.
Can we go down a power line? I mean, a
You
gas
could
line?
go, you could go that way too, Mike.
I'm assuming that he's gonna be.
At your own risk.
This is what we're.
All right, I think we've kind of beat this up enough for this evening. When do you
Oh, great, thank you very much.
anticipate getting answers back?
Huggins?
Alan, did he answer you?
No, I just gave them the email, so if they want to send something, or John needs something, they can send it direct.
Okay.
Rather than going through three hands.
And if what would, how should we communicate with him in terms of what I should be asking him? I'll send him the proposed decision and I'll ask him to call George.
It's got to go through the chairman of the planning board.
Okay. And then you can ask him
We'll forward our
Whatever you
questions
like.
also.
so that hopefully when we come back, he'll have responded to your specific questions.
When is your next meeting?
December 8th. I
Okay.
don't know if you feel is that a reasonable timeframe to get responses back?
I don't know, but I'm flying back in from a trip that day. And if I don't have a delay, I can be here, but I just don't know if the plan will be delayed. So I know you had asked about 5 members. I just wanna make you aware of that. I'm in a plane until 4:30 that day. So I might be in a plane till 8:30.
At Logan or at Green?
Green,
Okay.
so.
I believe, George, I'll have an answer by tomorrow night on what I showed you I was gonna send. That
The
piece anyways.
the next date out after that is December 22nd. Which may be close to a holiday. But if that works for everybody, does that
Yeah.
work?
It's fine.
All right, thank you for your time.
I would look for a motion to continue the public hearing to December 22nd at 7 PM.
So
Is that good?
moved.
Is that a good date for everyone?
Did you say December 22nd?
Yes.
Okay, so we're blowing off the next meeting in its entirety.
Well, I didn't wanna, I know you,
Okay.
you illustrated you wanted all 5 members
Yeah.
present, so
Yeah.
I didn't wanna risk it.
Yeah, I mean,
I
from,
mean, my plan is to come, but if that plane's delayed in Chicago,
I'd really greatly appreciate it if we could go for the 8th, and if he's delayed, then we'll ask for continuance perhaps, Mr. Chairman, but I'd like to err on the side of everything being on time.
I'll withdraw my motion for the 22nd. And I will make a motion to continue until December 8th.
Thank you all very much.
thank you.
All in
Have a great
favor?
Thanksgiving.
Aye, same to you.
Opposed? Abstained?
Thanks, Jack, appreciate you coming down.
Well, you don't think we listen to him, do you?
What was that? What you said?
I say, you don't think we listen to you, do you?
No, I didn't. Foolish if you did, any more than you listen to us.
Night, Jay.
Thank you.
You were gonna, Richard, you were going to email a copy of your, thank you,
Then we qualify. So they can determine.
thank you.
Let's keep moving.
They don't know what they're doing, that's why.
None of us do. That's the problem.
Do we have a file?
None of us do.
Yeah, it's under here somewhere.
If we had a bonus, if we had a bonus program, with you know, with a factor, we could probably get something.
I better keep this with me in
They
case
have
he calls
they
me,
have a project in mind.
unless we're gonna burn a copy. We wanna make a copy of this?
Yeah, it'd be helpful.
I'll put it in here,
There's a project
make
that
a
they-
copy and keep it with me. Element rights, that, proposal.
But my question is, is
Um,
that known village district in the TDR? But it doesn't say that. The TDR
Next on the agenda is a modification of Dollar General's ground sign.
I'm sorry?
We have a request to modify Dollar General's monument sign.
In what way?
General, where are they?
That was a big part of our conversation when we approved them. I assume that it meets the new town sign bylaws, but we had a big concern, David, in reference to visibility, being able to see around that sign. And so, how are they changing it?
Cranberry Highway.
They,
Back to what it was
they wanna
originally.
go from a 4x8 sign, basically,
No, 3x8.
3x8
is what-
sign to a 4x8 sign, with the height staying the same, adding a foot on the bottom.
They have a rendition of the two
Yeah,
different versions. The one on top is what they want it to be.
yeah.
The one underneath is what was approved.
I believe in our site plan, they pulled it back from the highway, so I don't think the change affects sight lines.
Side
And
of the old
I-
motel that
Yeah,
got torn down.
I don't have a problem with it. Could we get Charlie,
Okay.
who was instrumental when we first did this, to maybe take a peek at it, make sure that he agrees that there's no new limitations for visibility? Just, that's my only concern. I'm not, whether it's 2 feet or 3 feet or whatever it is, I'm not, as long as it meets the town bylaws for signage, I'm fine with it, but I would like to make sure that Mr. Rowley agrees that it's not adversely affecting visibility, which was the main reason I think that a lot of it was worked on.
Can we give Charlie the freedom to go and say yea or nay? And,
I-
take care of it, so
I-
you don't have to come back to us at all?
I would, I mean, I'm fine with that. Does that make sense to you?
Because, I mean, Mike beat up the sign pretty bad last time. Poor guy wanted to leave town.
No, he didn't wanna come back. Cost him a lot of money to come to Wareham.
20 times. We saw him 3. That's up,
Well, that's
wouldn't that,
building department.
I would think that that would be something that would have to be looked at by the code enforcement.
So a motion to accept this change as a minor
And to, so
change, provided
that it does not
affect sightlines.
adversely affect site view, and also that it does meet the new town sign bylaws still as far as dimensions and
Total square footage.
total square footage.
Second.
Good luck recording that for posterity. Any discussion? Hearing none, all in favor?
I think Mr. Reed's puzzled.
We're approving a sign as long as it complies?
It was, when we first were reviewing the applicant, a big part of the process was making sure, because of the location of the property, that visibility was clear, because there's some fencing issues, some landscaping issues, and the sign.
This is the sign that got approved on the bottom, and this is what they're looking to.
Does it meet the sound bylaw, or we don't know?
It does, yeah, it does.
It does?
But we wanna have Charlie Rowley give a formal opinion of it, so that's fine.
Okay,
That's fine.
so it's, when you said we approve it as long as it complies with the bylaw, I think,
No, Mr. Rowley,
Okay.
there's a square
that was my
footage.
question.
The sign's
Yeah.
bigger than the original sign, there's a square footage number you have to make sure you don't exceed overall.
All right, as long as he's gonna look at it.
3 feet off
Yep.
the ground, now they want 4 by 8, 2 feet off the ground.
is that okay?
Of course.
Any further discussion? All in favor?
Aye.
Opposed? Thank you.
Bob, you gotta understand, we're a very generous board.
We're
give a-
we're flexible, we're
We give a lot
flexible.
of freedom.
Flexible.
The next item was a discussion on a solar bylaw. Dave Moore called me and suggested we consider coming up with a bylaw to address large and small solar photovoltaic projects.
As currently, we don't have a solar bylaw, basically, is the point.
Mm-hmm.
You know, up to this point, it's been, if it's building mounted, it's building code, if it's ground mounted, it's a structure.
Hmm.
It's never been officially. This is one of the, this looks like a different one than the one I read, but Commonwealth of Mass, as well as a few other, is this Dartmouth?
Yeah, this I took out of the town of Dartmouth's bylaws, just as an example of what another town has done relative to solar. Sure, we could pull others from other towns to see what they have, but this one I was able to get fairly quickly, just so you had a sense of what another town has done to address this.
This is what you're submitting as a proposal, Dave?
No, it's just an
Just an
example.
example, okay.
And, you know, you guys can evaluate it, add to it, make whatever suggestions you think would wanna be something that the town of Wareham would wanna have, and then we could draft a document.
Okay.
I think if
I looked
you
at it
go
real,
online and look at the state's,
DOER, they have samples.
yeah, they're pretty explicit that you can't
I know that.
unnecessarily restrict, but you can have some say over.
Also,
Is it permitted?
Did you take new S-Rex they have? There's no more large-scale photovoltaic projects being funded.
But that could change with the next round of.
Could change in Bakeman, but as of right now, the state program,
They have
stopped-
changed their emphasis from
They stopped
large-scale
funding big
ground
jobs.
mounted to smaller scale building mounted,
Okay, we're a little behind the curve.
but that could switch back.
What does
And-
that zoning bylaw say now?
It's silent on it, so.
CBA.
So,
And the sample I read was dealt with large-scale stuff. I think we need to address,
We have a small
look at
scale.
small-scale
one
stuff
too.
too.
And I think Marion just did the small scale, if you wanna look at that.
That's where we kinda, when we did the wind bylaw, that we didn't address smaller
How
systems.
small is small?
Household units on the roof, all kinds of stuff like.
That's already a problem this time. No one's pulling permits, or hardly anybody, right?
Well, for a house-mounted solar, that's something you can just get a building permit for now. You don't have to get any special zoning approvals or anything like that. But some people have asked about ground-mounted solar in their personal properties, which is a little different, and that's something that probably should be addressed through this.
We've got one coming on my street, Oak Street,
Oh, really?
just they cleared the trees for it already,
Really?
yes,
How many acres?
just in front of the house.
In front of the house? That'd be nice.
Hope they tilt them so they don't blind you as you drive down the street.
It's just a freebie.
Like you can put on your stone wall.
Did you cut down trees while he was
By
gone?
your dock.
Kidding me? You're asking her to cut down a tree? Never happened. Ever.
That's good.
No, it's not.
So anyway, take a look at this, and you can go online and see some other examples of ground-mounted or solar bylaws. See if we can find something that will fit. And that's all I have on the agenda.
Motion to adjourn?
Is there anything?
No, just whatever you think you're gonna do for any zoning bylaws. Just get a list so we can get it in front of town council, so we can get, timeframes, everything else, and we don't do it last minute like we always do. Get it written, cleaned out quickly.
Mr. Chairman, how soon do you need our comments on the TDR application? Do we have a few days, or do you need them tomorrow?
No, if you do it in a couple of days, that should be all right.
Okay.
What is that, the elevator?
School department, the camera's shutting off.
For a
Oh, I thought
special
it was a
permit,
rewind.
or does
Save-
it really
save-
say?
Motion was made to adjourn, was there a second?
Second.
Any discussion? All in favor?
Aye.
Opposed? Meeting adjourned at 9:30, no, 27?
Yeah.
On the wrong side of the 6. Did you already shut down, Bob?